Welcome back to the Regent Law Podcast with another episode of Constitutional Conversations, where we seek to make constitutional law more approachable. Really excited about this episode as always. I have Professor Christian Edmonds from Regent Law with me, and we're really excited. We have rising 3L law student Greta Griswold with us. Greta, how are you doing?
I'm great. Excited to be here.
Good to see you, Greta.
Well, we're excited here at Regent Law. We just honestly, I think we just love the relationship we have with students, and we're proud of the student experience. I was a student a few years back ago, and I think that's a strength of our law school. So we're excited to have Greta with us. Greta is an exceptional student. She's going to be a 3L this year. She actually works in our Constitutional Law Center with Professor Edmonds. So we're excited. She is a contributor today to the episode. I'm kind of along for the ride. Today we're going to be discussing the question, how should we read or even interpret the Constitution? For our listeners, maybe you've never thought about that question. Maybe you just think we have the Constitution and we use it to govern our country. What's the deal? Let me ask the question behind the question. Professor Edmonds, why would we even ask that question? Isn't it just a singular document that hasn't been, changed or amended for a long time? So why are we even asking the question, how should we read it?
Well, I think an uncontroversial statement is that this document, this is my little pocket one I use, is binding. All right, we all think that it is binding. And if it is binding on us as the people, then we have to know what it means. And for the last couple hundred years, we've been arguing about what it means. You'd think, you look at this thing, look how thin that is. It's that thin, yeah. And this has got a lot of minutia at the end. This thing is not very big. You look at some other, and that's one of the things that's unique about the United States Constitution. So you go to other countries, and the Constitution is this thick. This thing is this small, but it has caused thousands and thousands of debates on what it means. And so kind of today, I think Pat and Greta and I are kind of wanting to just dissect, well, how do we interpret it? That's really the key. And there are law school classes, I was in one of them, that this is all they talk about. We're going to just touch the surface today and go through a few of the methods we use to interpret these words. Greta was in Con Law 1 and 2 with me, so I would appreciate her interjecting at any time as I drone on, as I'm prone to do. But let's just quickly go through the modes, and then we'll talk about them a little bit. So the first one, and these are broad headings, and there's some subpoints to them. First one is textualism. That kind of makes sense, right? We're reading the text for what it is, but there's different ways of reading the text for what it is. And then the second is argument by consequences. Consequentialism is kind of a broad way to put it. And then the third is past practice. All three of these have very different ways of interpreting, but these are what I have kind of dissected for our purposes today as the three primary modes of interpretation.
And would you say, you're describing, and probably within those views, there's even disagreements. So what you're really talking about is it's not even always known. But when a person comes and reads the Constitution, they're likely coming from one of these camps and using an interpretive theory or perspective on how they view how this document should be binding and governed today. How should we apply these to modern life?
Yeah, these words, right? Here's a great example, and we won't get into the merits of this. What the heck does it mean to have the right to bear arms? What does that mean? You have to have a way of interpreting it. Do you interpret it through the modern context of what we understand firearms to be and their utility in our society? Do you want to understand it from those that drafted the Constitution, actually like James Madison and these ratifiers? Or do you want to know what the general public at the time of the ratification or the ratification of the amendment thought of it? What have we done for hundreds of years? That's another way of looking at it. So these are all various methods of trying to determine what those words, right, to keep and bear arms, what do they mean? So if you don't mind, I'll just go through and just kind of very quickly detail kind of some of these nuances, because I think it's kind of interesting. I think all this is interesting, though, so you all alert me when it gets not.
Yeah, I think quickly break down the three.
Okay. So textualism kind of breaks down into 2, maybe 3 ways. One is just straight up textualism, right? We're just reading the words for what they mean, and you can look at the meaning in a contemporary sense. Not to get into the weeds of this, but Justice Black, who was a very famous justice on the court in the 20th century, that is kind of what he did. And he is really the father of textualism. He wanted to know what the words meant. But there's a offshoot of textualism, and this is the one everyone's going to know in today's day and age, is originalism. Originalism wants to know what the text means, but it wants to know what the text means from an understanding of when it was written, right? So there's various ways of doing that. I kind of detailed it already. Do we want to know, bear, and the right to keep and bear arms, just keep using this analogy. What does bear mean? Well, there's a few ways you can understand it from originalism. It's what the public thought. Like, what's the public understanding of the word bear
at the time it was
written? Or another way is to look at original intent. And I said this earlier, what did the drafters think? This is something that happens a lot in the 14th Amendment, right? 14th Amendment's Equal Protection Clause, Due Process Clause. What did the drafters, when, these legislatures, what did they think when they were drafting the 14th Amendment? What was going through their mind of what those phrases and clauses meant? So that's another way. And then one that I've tucked under here that I think I'd get, if this podcast, if my colleagues are watching, they'd balk at this, but I am going to tuck into textualism structuralism, right? For example, if a certain power is housed in Article 1, which is Congress, then we probably aren't going to say that the executive has that power, right? Because it's where it's structured. And you've heard this buzz phrase, separation of powers, right? That's a way we interpret through the text is who has this power, where's it housed, what's the scope of it.
Okay.
So that's textualism.
Okay, we got to move on to the second one.
Okay, second one is probably the most interesting, and it's consequentialism. So there's a couple of modes of understanding this. One is just a pure basis of pragmatism. I wouldn't go so far as to say he's a pure pragmatist, but Justice Breyer, who just left the court, looked at things from kind of a functional standpoint of what works best for the societal position we're in now. I don't really.
So this is just somebody who's practical.
Yeah, it's practical. I mean, it's kind of like, the nuts and bolts. We treat constitutional interpretation like we treat plumbing. Let's just fix it to what the current circumstance is. And they don't really care what James Madison thought in 1790-something. You care what's going on right now and what problems is our society and culture facing, and how can this document help fix them? That's one mode. The other one is really from kind of a moral reasoning basis. What is morally just? What is the morally correct way to interpret this document? One way this can come into play is like, what does equal protection of the law mean? That is a vague phrase, right? And we have, through practice, interpreted that to be anti-discrimination. And that has a basis, I think, historically. But I will say in a lot of the cases we have in the past, there's just been an idea that this is the right way to do things. And that's perfectly fine. That's just a way of interpreting the Constitution that's not really grounded in the text. It's grounded in this is just the right way to do things. I do think there's a way to ground that type of reasoning in the text, but that's for another episode. But that's consequentialism. It's pragmatic. It's based on what is happening here and now. Modern interpretation is another way to put it. And then the last one is simple. It's past practice. There's a couple of ways to look at this. We're going to talk about it in another episode, which is precedent. The court does this all the time, right? We have an idea of what we might think is the right way to do this, but precedent, past cases, have decided this factual legal circumstance a certain way, and we're just going to apply that. And then another means of past practice is not really based in case law, but this is just what we've done forever. Right? This is how the executive has acted for 200 years. It's not really based in cases. It's just what we've done, and we think that's a good thing and is persuasive, and so we're going to keep acting in that way. So these are the three modes that, again, others would quibble of how I've structured them, but I think that's the best way to understand this.
So when the average person would think about the Constitution as a binding document on life, they would often not know what camp they're in. They're just operating from those places, unless they are legally interested. Greta, as someone who came to law school, when you were thinking about the Constitution, I can tell you, I had never read the Constitution. I had no idea of the interpretive viewpoints, didn't know what I was. Where were you when you came to law school? Did you have a clue about any of this?
No. I think before I jump into where I was, I think one other thing that would be helpful, just if you have to boil this stuff down all the way. Textualism is basically the Constitution has a fixed meaning. Fixed, I think, is the word that would be helpful. Consequentialism, the meaning is fluid. Sometimes, you're lawyers. I want to be a lawyer, having words that all start with the same letter. Thinking like, do I think the Constitution is fixed, or do I think it's fluid? Or am I just cool with whatever the court has said about it? That's the simplest way, I think, to look at it. And I think
I like that. I'm feeling that.
Now let me push back. So a person on the fluid side might hear like, whoa, are you defining me correctly? Because fluid sounds, it sounds weak. It doesn't sound like planted anywhere. But when you're saying fluid, are you saying that they would say that's necessary because time evolves? We evolve over time. So that it's not just fluid, like shaky. We don't have any kind of anchors anywhere. They're just saying society changes and this should too.
Exactly, because it's really how do you determine meaning is what we're talking about. So with fluid meaning, it's not to say we've got no structure, we've got no foundation, but that changes as people change, as society changes, as our values change. So fluid in that sense, that you're not going to look at one particular time and say, this is how we know what it means, because it might mean something different today than it means in 50 years. So,
and I will just put this in there to really put it in practical terms. Greta and I talked about this a lot in class. A great example of this, we talked about equal protection of the law, right? It is not controversial to say that it was not on the minds of the drafters when they were writing the 14th Amendment dealing with sex discrimination. That was not something they were dealing with. They were not thinking about equal status of men and women. All right. I think you can make a argument from the text based on kind of like a hierarchical system. We don't want to create a hierarchical system, but we have cases. Greta knows those cases that we read in class that have very nasty, bad language about the idea of women's role in society from that period. Supreme Court cases. And so that's a good example of, do you want to look at something from a fixed understanding of what the drafters thought at the time, or do you want it to it to evolve and change? Now, I would argue that the text gives us the answer because I'm a textualist and an originalist. But if you look at it from an original intent, what they were thinking, and there's no way you can get to sex discrimination being protected. And so there's a lot of consequences to these modes of interpretation is all I'm trying to say.
And getting back then to where I was, I think that leans into it and why I approached the Constitution a certain way, because it was really hard for me to say, okay, well, I wasn't on the mind of the drafters of the Constitution. People of color weren't on the mind of the drafters of the Constitution. So why should I care, what they meant? Like, that seemed unjust to me, I'm like, is this
so the idea of originalism or textual in the beginning felt no way.
For sure. And I thought, no, this is just something that super, super conservative people want to support. I mean, there's nothing wrong with that. And I think part of it was I, like you, had not taken the time to actually read the Constitution. So it's not really wise to have an interpretive framework when you haven't read the document. But so I came in and I was very pragmatic. And I introduced myself that way, I'm a pragmatist. I care about the consequences of this because to me, I got into law to help people. And so it made the most sense to me to say, how is how we interpret the Constitution going to affect people? And let's make interpretations based on how people are going to be impacted. I still care about that, but I was really challenged on, I mean, I came into constitutional law and thought, now Professor Edmonds knows everything I'm about to say, so it won't be a surprise. I thought common law was going to be a class that I just had to get through. Like, I don't care about the Constitution. I don't care about constitutional law. I'll just have to grind through this. And now I really care about it and even like laugh about silly things about the Constitution. But I think one of the biggest impacts for me, and I think for probably people who go to a school like Regent, is I do have an interpretive framework for how I read a really old other document.
Yeah.
You know, I do have a very specific interpretive framework for how I read scripture and how I read the Bible. And it is not a pragmatic consequence this way. So I was really challenged. Now, to be clear, I in no way think the Constitution is on the same level as the Bible. But just thinking about how you interpret something that was written a long time ago, I realized when I approach the Bible, my question is, what does it say? And one of my next questions is, what did it mean to the people it was written to? Then, how does this apply to me? And so I realized, oh, maybe I should also read the Constitution that way and think about it that way. And I still like really wrestle with that because I think there are some times when the outcomes of reading it that way aren't exactly what I want. But I think one of the most helpful questions that I was asked this year when thinking about constitutional interpretation is, what tool do you want in the hands of the Supreme Court justice you disagree with the most?
Wow.
What tool do you trust in their hands? Do you want them to be making a consequence argument based on what they think is right? I don't.
Wow.
You know, I don't want the person that I most disagree with to just say it means whatever they think it means. And because I'm only actually okay with pragmatism when it's an outcome that I agree with. And that's what I had to, you know, be confronted with. And I think the time where I was most confronted with this, and it pained me to do so, we were reading a case that was written by Ruth Bader Ginsburg, whom I love and respect. And I, in class, raise my hand and say, you know, I think Justice Ginsburg, that's not what the text says. What she is saying is not what the text says. And I was shocked. You know, I'm not the kind of person who frequently criticizes Justice Ginsburg. And
that's really humble. This is a hero of yours in the legal context, which you're pursuing a legal career. So this woman who's done so much, and you respect her and her conviction, and you're like, this isn't lining up.
Right. Like this isn't what it says. And it's not what we've even said about it before. So I think the thing that was helpful for me was constitutional interpretation is not just about how I want to approach the text. It's how I want everyone to approach the text. And I think once I really worked through how do I feel about people who disagree with me interpreting this text, that helped me land at, oh no, we all really need to be asking the question, what does it actually say? Something, you know, with textualism. And then what did it mean when it was written? Now, I think there are cases that have gotten that wrong that I'm glad got it wrong. But if I look at the reasoning, I'm pretty disappointed. For instance, and I think we'll talk about this later too, Brown versus Board of Education, which said, you know what, segregation in public schools is not okay. That violates the 14th Amendment. If you look at the constitutional reasoning in that case, it's not great. They really use a lot of sociology to support the opinion. And that is a case that I'm very happy with the outcome. But when I look at it, I think that's not how we should have gotten there. And imagine where we could go if we just bring in all sorts of outside opinions or thoughts for a document that does mean something.
Wow. That's really helpful, Greta. I love what you're talking about with scripture. I went to seminary for a little bit, and we were battling on what should we think about the authority of this ancient document, inerrancy or infallibility or whatever. And then when I took common law here, I felt, wow, this is such a similar discussion. Well, I don't really know how to wrap it up here. Professor Edmonds, do you have any closing thoughts? I mean, essentially, I think it's helpful for our people who are navigating or wading into the constitutional waters, like we always say on these episodes. If the only thing you know about the Constitution is what you hear on the news, you're going to have a really warped view of constitutional things happening at the Supreme Court level. But even the arguments and the rights that we have as Americans and what's up for grabs. So this is an interesting episode because we're talking about, I mean, how does this play out in constitutional law? Where do these different interpretive views and perspectives, how does that play in the constitutional landscape?
Well, we're kind of going through a constitutional revolution right now. I think many would say that. Now, since the 1980s, we've been dealing with this idea of originalism, and it's been gaining a lot more force. But I think it's actually come to be the predominant view of the court. Justice Kagan, who is not a conservative justice, has said we are all textualists now. Now, there are different ways of doing textualism we talked about, but it has shown itself in recent cases. We're going to talk about it in another episode, but Dobbs. This is an originalist case. Bruen, a Second Amendment case. It is an originalist case. Kennedy, and a religion clauses case. It is an originalist case. All of these cases are saying in order to understand fundamental rights, these provisions of the Constitution, we have to look at what? History and tradition to determine the meaning and understanding. That is originalism. And you're getting pretty hefty majorities of the Supreme Court saying this is the way we should do it. So whether you agree with it or not, the train's leaving the depot. This is how they're going to do it, at least for the next couple of decades. So we'll see what happens in the future. But yeah, this is where we are at in a constitutional moment.
Fantastic. Thank you so much, Professor Edmonds and Greta. I learned a lot, and I imagine our listeners will learn quite a bit from this discussion. It goes without saying, there's a lot you could read about this. And if you're interested in this topic, there's plenty of books on this topic or articles. And it's important. How do we view this limited document that has benefited our country for hundreds of years and provided an amazing context for our society to thrive? As always, you'll see in the summary of this episode, you'll see kind of more information to learn about Regent Law or the Robertson Center for Constitutional Law. And we hope to see you on the next episode. Thanks.